Get ready for the dictation in 3, 2, 1, start. Mr. Anshuman Saxena for the accused appellant stop. Mr. N.S. Shekhawat, public prosecutor for state stop. Present appeal is directed by the appellant Ram Karan against the impugned judgment dated 19/5/2007 rendered by the Court of Additional Sessions Judge Fast Track District Jaipur stop. The said court void the impugned judgment, held the appellant guilty of offences under section 302, 201 and 404 IPC for having caused murder of Kishan Lal stop. The trial court having convicted the appellant for offences under section 302, 201 and 404 IPC sentenced him life imprisonment to pay a fine of rupees 5,000 and in default thereof to undergo 6 months additional imprisonment stop. 3 years simple imprisonment to pay a fine of rupees 1,000 and in default thereof to undergo 1 month additional imprisonment stop. 3 years simple imprisonment to pay a fine of rupees 1,000 and in default thereof to undergo 1 month additional imprisonment stop para. Shri Ansuman Saxena, learned counsel for the appellant, has read the charges framed against the appellant stop. The first charge stated that between 30/6/2005 to 2/7/2005 in the revenue state of Biharipura, the present appellant, after committing unnatural act, had thrown Kishan Lal in the ravines of Dadar stop. The only thing which we need to notice from the charges is that the occurrence had taken place between 30/6/2005 to 2/7/2005 stop para. Shri Saxena has drawn our attention to document Exhibit P17, a certificate issued by the Government Upper Primary Secondary School, Biharipura, Amer, District Jaipur stop. In the school certificate, date of birth of the appellant recorded is 8/7/1987 stop. Thus, it is contended that on the basis of school certificate Exhibit P17 issued by the government school first attended by the appellant was less than 18 years of age on the date of occurrence. Hence, he is a delinquent juvenile in conflict with law. Stop para. Shri Saxena has relied upon Hari Ram versus State of Rajasthan and another 2009-13 SCC 211 to contend that as per section 2K 2I 7A of the Juvenile Justice Care and Protection of Children Act 2000 and Rule 12 of the Juvenile Justice Care and Protection of Children Rules 2007 read with section 20 of the Act of 2000 as amended in 2006, a juvenile who had not completed 18 years on the date of commission of the offence is also entitled to the benefits of the Juvenile Justice Act 2000 as if the provisions of section 2K had always been in existence even during the operation of the 1986 Act stop. The said position has been re-emphasized by virtue of the amendments introduced in section 20 of the 2000 Act, whereby the proviso and explanation were added to Section 20, which make it even more explicit that in all pending cases, including trial, revision, appeal, and any other criminal proceedings in respect of a juvenile in conflict with law, the determination of juvenility of such a juvenile would be in terms of Section 2I of the 2000 Act, and the provisions of the Act would apply as if the said provisions had been in force when the alleged offence was committed. Stop para. Shri Saxena has further urged before us that Section 7A of the Juvenile Justice Act 2000 made provision for the claim of juvenility to be raised before any court at any stage, as has been done in the present case, and such claim was required to be determined in terms of the provisions contained in the 2000 Act and the rules framed thereunder, even if the juvenile had ceased to be so on or before the date of commencement of the Act. Stop. The law, as now crystallized on a conjoint reading of Section 2K, 2I, 7A, 20, and 49, read with Rules 12 and 98, places beyond all doubt that all persons who were below the age of 18 years on the date of commission of the offence, even prior to 1/4/2001, would be treated as juveniles even if the claim of juvenility was raised after they had attained the age of 18 years on or before the date of commencement of the Act and were undergoing sentence upon being convicted. Stop. Since the appellant was below 18 years of age at the time of commission of the offence, the provisions of the said Act would apply in his case in full force, and on the date of the incident, it has to be held that he was a juvenile. Stop. Thank you.